We are live.
All right, good morning and welcome to the House Environment Committee. We have posted on our agenda that we are going to, I just had Michael back on what's not in our possession, but H319, an act relating to miscellaneous environmental subjects. To see if members, having had some time to consider the walkthrough, the side-by-side we did yesterday, had questions for him. Do you need more information? Do you need to hear from other witnesses? What will you need to find your way, hopefully in support of that bill? Anyone have questions on that? Okay, well, let me know if you do. And then we considered yesterday an amendment to S124. And I guess I will just say that for me, I've been thinking a lot about this, and I feel like the bill for me, I wasn't expecting, nor did I think we needed to actually have this conversation this year, but we're having the conversation this year around the dedelegation petition. And I feel very strongly that we not tie ANR's hands behind their backs by limiting their authority to the existing Clean Water Act, but that we include the amendment that we considered yesterday. And happy to have discussion on that right now, or since, like I said, two members are not with us, it would be prudent to wait till we're all back together to have a vote on that. But I don't know if others have thoughts they want to share now, or you want to just postpone that until we can get everybody here. Okay.
Seems like it's the current thought that the current status is what we viewed yesterday. I think there's no more new amendments to it that we're aware of.
Right. The amendment we looked at yesterday is, I believe that we need to pass that as we walked through it yesterday with Michael, for the reason I just said. I feel like the evidence is actually really clear if you go back to the testimony that we've taken, that we have a dysfunctional situation between two agencies, and that as the people who direct policy, it is our responsibility to address that dysfunction. And for me, as the person in charge of the Environment Committee and water quality in the state of Vermont, Agency of Natural Resources needs to have the tools, all the tools they can available to them to do their job. And this amendment as drafted begins to move us in that direction. And without it, I don't believe it does that. And I know that a lot of you have been compelled by this argument of lack of trust that the Agency of Agriculture has in presumably the future Agency of Natural Resources, but that is exactly the problem, is the lack of trust. And we need to address it head on. So I'm Representative Bartholomew.
What tools do they currently lack?
We heard one example yesterday from our legislative council. If Michael, you want to say that again, or if you have other examples.
So I think the question was, what could the agency enact that's more stringent than the federal CAFO regulations? And that would be allowable under Federal Clean Water Act, just precedent. You heard Catherine Gessing say that the Federal Clean Water Act allows states to be more stringent, and I totally agree with her. And in the CAFO program, one example is the federal CAFO program allows for discharges due to the 24-hour, 25-year rain event, whereas Vermont currently does not allow for that type of discharge. So if ANR wanted to, as part of their CAFO rule, they could be more stringent than the feds and prohibit the 24-hour, 25-year flood event discharge allowance.
And what's keeping them from doing that now?
Well, the language that was proposed in the report from the House and supported by the report from the Senate and supported from the report from the Committee on Agriculture would require it to be to only meet the requirements of the Federal Clean Water Act. So the Agency of Natural Resources could not be more strict than the Clean Water Act.
So in fact, we'd be limiting them because currently, if we were silent on it, they could be more stringent.
So
Currently,
that's
if you're-
just one portion of the amendment. The stringent part of the amendment.
Mhm.
Yeah.
So that is the debate is, do you, I mean, it's a policy debate. It's, do you allow the agency to do what it does already under Federal Clean Water Act precedent and how it interprets the Federal Clean Water Act now and be more stringent? And often that's in response to the legislature telling them to be more stringent. Or do you tell them just do what they have to do in order to comply with the CAFO rule, which is just meeting the federal CAFO regulation? I mean, that's your policy decision.
Any other questions on the amendment? Representative Jacob?
I just wanted to make sure that we did offer one change yesterday around the date to March or April 1st. So I just wanted to make sure we captured that.
And I've updated the amendment. I haven't sent anything because I did not know what to send today.
I support the change of the date. And I wonder about changing the date in 319. But that, I think we don't have 319 yet, so, but I would like to bookmark that as a change that we also make to April 1st, just so it's just. Representative Sakowicz.
Yeah, I guess given what we just heard, I guess I've just wanted to elaborate that and make sure I understand that if we keep the current language in the bill without the amendment, then in a sense, we're taking a step backwards in terms of
You're capping
quality.
You're capping what A&R has to do for the CAFO program. You're saying that they just need to meet the Clean Water Act regulations.
But the way we've set it up in the past is that A&R has been given the authority to do more. And in this case, we'd be saying, no, we're going to pull that back. And in this particular realm, you're not going to be able to do more.
Right.
So broadly speaking, we would be pulling back what A&R is able to do in response to
For this program.
this. Yes.
For example, the Federal Clean Water Act requires all states to have water quality standards. And your statute just tells the agency to adopt them with, some decent criteria, but the agency has gone well past the Federal Clean Water Act and the criteria and statute because of what you delegated to them. And they're pretty good standards. They're pretty good rules. When you compare them to other states, they're good. And so, I mean, that's how it operates now, but it doesn't have to operate that way.
Right.
You can tell them what their authority is.
Or doesn't, right? That's what we're discussing. But it's like, I mean, I feel like A&R has done a really good job, of creating the rules they need to keep our water clean. And so the idea that we would somehow say, well, in the future, in this particular area, we're give you the same kind of authority that you've traditionally had and made good use of in the past, I'm not sure why we would want to do that.
All right, further comments? Representative Morris.
Madam Chair, thank you. So this bill came to us with language that basically is equivalent to the federal. And that is seen as limiting the authority, which they're already conceivably doing. So we talked about changing that to as stringent as, and then we updated that to comply, and now we're back to as stringent as. And it's just wordsmithing in statute around the authority that they're already have been asked to do to keep our water clean and safe. So I'm okay with that language. And then the second component we talked about having them set up an inspection plan. It's not requiring them to do inspections. It's set up the plan. to let us know in the future, or to report back on what they're doing. I'm comfortable with it. And I think I can support it. Yeah, I know I can support.
Representative Austin.
I just want to say, again, representing 18,000 Vermont constituents who have for the past 10 years seen their bays, turn green and be compromised because of ag discharge. And wondering, even before I was a legislator, why isn't this being dealt with? I feel like they've had an opportunity to address this issue and have not been successful. And I feel that ANR has to have as much power as possible to get this situation cleaned up.
Bartholomew.
I keep coming back to the fact that from what I'm seeing and what the agency is saying, that their relationship is not dysfunctional, that they are reporting appropriately. And I'm troubled that both agencies do not support this. They would rather see the bill as we received it from Ag. I keep coming back to that. And also, I'm really troubled by the Digger article that came out last week about the Vorsfeld farm? Vorsfeld, where, they want to add 580 cows and they're being held in contempt because they're not following the water quality. These are the kinds of farms that are going to be really causing the problem. Small farm with a discharge, not good, but it's not going to be one of the big players. It's going to be farms like this. And this kind of situation, ANR already knows about it, and they either cannot or will not do what needs to be done to stop it. And it's also not like a factory where you can just say, okay, you're in contempt, you're shut down, and then the assembly line stop. You can't just turn off the cows. So-
A court could do that.
Turn off the cows?
Or could say cease
Yeah,
operations.
where would, then the cows would have to go somewhere.
To-
Yeah,
to-
right, okay. But in terms of practically, it's not like tomorrow, you can't just flip a switch and the cows stop pooping. But I guess my point is, this is the kind of operation that's going to really contribute the biggest problem. And ANR already knows about it. They already have the authority to act. And for whatever reason, it's not being fixed. So I don't see that this amendment helps anybody except annoying the two agencies. I can support the at least as stringent as, but
Well, that's what we're talking about. What are you talking about?
I'm talking about the increasing the inspection so that they're having to go expand their inspection to other smaller farms that if there's a problem reported, or that if Ag finds a problem, they're already reporting. We've been told that.
So there's differing opinions to the one that you have on that topic. And I guess we actually, that's the universe we know the least about. We know the most about the LFOs and the MFOs. And the smaller farms are the ones that we know the least about. I don't want to speak for folks who've been in this room, but I know that there are some farmers who feel like actually there are going to be some small farms that need to have CAFO permits. I mean, I think we don't know what we don't know with small farms. It's really the reality of it. And I think maybe they're working better now, but when I looked back on the testimony we've taken, it's pretty clear staff is stressed, things are not working well, and we need to move the ball forward to address the issues. So I struggle, Representative Bartholomew, to understand how we changed it from a mandatory inspection that ANR actually said they could do by 2028. They did say that, to come back to us and tell us what inspection schedule is necessary to meet these needs. And that seems a lot softer than the original request. And I'm struggling with why it is you wouldn't. For me, that's accountability. We need to know what the Agency of Natural Resources is doing to do their job, which we all acknowledge hasn't really been happening consistently. So what we do here, we say like, okay, we're setting up a legal framework so that the work gets done to what we set the policy at. Instead of shaping them afterwards.
And just to build on that, I think it's clear, but it doesn't feel like it's clear that EPA is requiring the inspections.
Yeah.
Not the legislature. EPA has been extremely clear in its letters to the agency that they must be the entity that goes out and examines on farms whether there's a discharge and whether they need a NIPD's permit. And so the agency is going to do that. Exactly when and how is what we're trying to understand, and then ultimately put that framework. So I just, we need to be clear. The EPA is requiring the inspections.
Yeah. Representative Zachary.
Yeah, so, so all we're really doing is asking A&R to report back to us on work which they're going to be doing.
We're gonna do anyway, whether we pass the
We're just
bill.
asking them to tell us what they're coming up with by a certain date.
Representative.
So we've talked about two of the topics, and the third topic that I do appreciate is the inclusion of the clamping to a particular date of the regulation, so it's not floating. So that just reduces everybody's uncertainty, everybody's risk. We all know what we're specifically talking about, not worry about changes. It's good.
That's a great idea.
All right, so we'd like that amendment back with the date change when you have a chance. When I think we'll just we'll take this up again at 11 when you come back.
Specifically, which date are we referring to changing?
The date on the sunset for linking it to the current Clean Water Act. It's now January, the clamp date is January 1, 20.
January 31st, 2029?
Yeah.
31st.
Yeah.
2029
Yes,
Right.
I suggested just moving it to the end of March or April.
of that session. the
That same
2029
session, just so that there's a couple months if the legislature wanted to do something
Yeah.
other than let it sunset.
And we're talking about, did you say May 1st?
April
We said
1st.
April.
A little tight.
So it's still a little tight, but it's.
I mean, we could do May. Maybe it's whatever. Sort of.
No, yeah, it doesn't.
Yeah. Just I think
Just as long as
a
it's
little
more
more
than a few
time.
weeks.
Yeah, more than four weeks. All right,
So May,
April 1st. We're gonna stick with it.
okay,
All right.
English Day.
Chosen for a reason.
Had to say it. All right, great. Thank you all. So then, we're gonna walk through now, 238, which is the PFAS bill. Oh, go ahead.
When do we think we would vote on this amendment with the change?
Today at 11.
Today at 11. You're coming back with that.
I'm always supposed to be here at 11.
Yeah. He's gonna do the PFAS at 11, but we will, I think have time to do whatever we need. Council
For
O'Grady.
those online, this is the warning that we're voting.
Yeah.
Okay, thank you.
Okay. So you should have side by side a 238 on your committee website. I'm gonna walk through with page numbers, and in order to see the page numbers, you have to download in Microsoft Word. The differences between the two are highlighted. The first difference is in the definition of intentionally added. You will see that in your definition, there was that reference to the addition of the chemical in a product that serves an intended function in the manufacturing of the product or in the final product and results in PFAS in the final product. You said that the addition must be known or reasonably ascertainable by the manufacturer and shall not be considered intentionally added if the chemical is present in the product due to use of water containing PFAS. Now, the manufacturer took no action that resulted in PFAS being present. The Attorney General sent a letter to the Senate Health and Welfare Committee saying that they did not like that definition and that they were looking for something that was provided more clarity and to the regulated community. The agency, the AG, and the regulated community sat down and they have proposed this definition. means PFAS added to a product regulated under this chapter, one of its product components to provide a specific characteristic, appearance, or quality, or to perform a specific function. Intentionally added also includes any degradation byproducts that are intentional breakdowns of, or PFAS that are intentional breakdown products of an added chemical. For purposes of the chapter, the use of PFAS as a processing agent, mold release agent, or intermediate is considered intentional introduction where PFAS are detected in the final covered product. Later on in the bill, there's a report from A&R about PFAS regulation in other states. Part of that is going to include how or if other states regulate the presence of PFAS due to water, due to the use of water. So you'll not totally abandoning the concept of PFAS in a product because of water, but it's not going to be part of the definition. It does not exempt the presence of PFAS because of water. It would still have to be PFAS that's added to the product or product component to provide a specific characteristic, appearance, or quality. So basically, under this, the water would have, and the PFAS in it would have to be added to provide that specific characteristic or appearance. And that's not going to trigger, people aren't using water to introduce PFAS into a product. And so that's that first definition. The second is because you're no longer using the known or reasonably ascertainable in the definition of intentionally added, that was struck. There was also a request from one of the members of Health and Welfare to exclude children's all-terrain vehicles, as that term is defined under 23 VSA Section 3801. There was discussion in that committee of whether all-terrain vehicles are juvenile products, because whether they're designed or marketed for use by infants and children under 12 years of age.
Why is that being added?
Pardon?
Why are we excluding children's all-terrain vehicles?
Because they have PFAS in them and they're complex durable goods, and they,
Do their other amendments add complex durable goods back in? Because we didn't.
no, it doesn't add complex durable.
This is a future ban.
Right.
Okay, that's.
This would go into effect in 2026, I think.
Right, regardless of whether we address complex durable goods.
Right. There was a concern from one of the members of Health and Welfare that without clarification that an ATV marketed to juveniles would be prohibited from having PFAS in it.
Good. Representative Bartholomew.
What is a children's ATV?
So coincidentally, I was driving home from work the day after this subject came up, and two kids were driving ATVs on the sidewalk in South Burlington. And they were not 12 years old or more. And so it was an ATV. It was, I don't know how to explain it more than
Like a
that.
thing with a motor that.
It was a literal, they were not like farm grade ATVs. They were more like the race grade ATVs. And they were doing wheelies and all kinds of stuff on them.
Didn't know there was such a thing.
You ever seen this riding
Representative
on their ATVs?
So should I move on?
Representative
I
Austin.
just wanted to say that yesterday, when I was dropping off some dry cleaning, there was a kid, he couldn't have been more than 8 years old, on an ATV, riding up with his sister to go to the general dollar store. And I'm thinking to myself, we need to do something about this.
Well, that was probably a regular ATV.
No. It was like a tiny little bike. Yeah, tiny.
Apparently the Senate wants to exclude them. Representative Chapin.
So I'm confused. I think what I hear you saying is that apparently our because of the way we defined juvenile product and have juvenile products in here, that complex durable goods, while otherwise excluded for a period of time, if they're a juvenile complex durable good,
So the way that, the way the juvenile product is defined in law now and in the bill, it would include an ATV that's marketed to a child that's 12 years or younger.
but also any other complex durable good that's marketed to children under 12.
Potentially, yes. But you already have an exclusion for the electronic products, which are already most of the complex durable goods that are marketed to children. They are already excluded.
And then would these items, it's been a while, even though I reported this bill, can you remind us how we deal with complex durable goods later?
There's a report back from ANR in 2033 regarding how complex durable goods are regulated in other states with the broad definition of PFAS and how they recommend to manage complex durable goods going into the future.
Thank you.
And Health and Welfare added 2 checkbacks on that because they thought 2033 was too far out. So there's going to be checkbacks on that as well.
So we're sort of leaving this open for any other complex durable good that that's marketed to children that we didn't exclude might get caught up in this and be banned.
Potentially, yeah, but I do think because you're excluding the electronic products, you're already excluding most of the complex durable goods that are marketed to children. Remember, it has to have 100 or more parts in it.
Okay.
It's like going through the express lane at the checkout, but 10 times.
ATV.
Representative Bartholomew.
Just to be clear, though, Representative Morris is showing me a picture and mentioned the ATVs that the Shriners use in parades. Are those would be excluded because they're
For juvenile.
I don't know
Look,
the Shriners purchase.
This is 1984, but the purchase. They're all 4-wheel now, but they're designed and marketed for children.
So if they're designed and marketed for children, they would not be subject to the PFAS ban.
if we accept this amendment.
Right.
All right, moving on.
Okay. The rest of the definitions are renumbered because you took out the known or reasonably ascertainable definition. The prohibition on most products is the same. There is actually one change that I did not highlight. It's on page 7. It's in that subdivision A8. The ban from Act 131, it was on residential rugs and carpets, and that was on me. That was my fault. I left residential out in the listing of rugs and carpets. So residential rugs and carpets is really the category that was prohibited under 131.
Which means in your office, you could still have.
And that's what 131 did last year, yeah.
Yeah, great news. Yeah, or roll your chair across the rug. That's right, that we're all on right now.
So then the next change is in relation to the fluorine treated containers. Remember, you had that ban on fluorine treated containers or any consumer product in a fluorine treated container, but you gave the Attorney General the authority by rule to allow the sale, for sale, et cetera, of a consumer product in a fluorine treated container or the sale of a fluorine treated container if there was a currently unavoidable use that needed to maintain the use of the fluorine treated container. The Attorney General does not want this authority, wrote a letter that said prefer not to have this if there's concern about the availability of alternatives to just push out the effective date of the ban. And that's what Health and Welfare did. They moved the ban from 2030 to 2032, and they took out the authority of the Attorney General to have exemptions for currently unavoidable use. Could I move on? The next difference really is in the report. Remember, going up section 4, there's that report from A&R to you, the General Assembly, summarizing programs in other states, how they implement regulatory programs, et cetera. As I referenced earlier, they are going to address whether other states have prohibited or restricted the use of fluorine-treated containers, including a summary of how fluorine-treated containers are used or allowed for use in other states, and then a summary of PFAS data and industrial processes to the extent available, and whether any other state has restricted the use of PFAS contaminated water in manufacturing.
Remind me when that report comes back.
That's the 2033 report. Oh, no, 2027. 2027. The 2033 report is the next section. That's the reports on PFAS and complex durable goods and food. Health and Welfare wanted the report's title to specifically reference those two subjects, and that's a difference. The report on complex durable goods is the same. There's a typo that was fixed to clarify that there isn't a House Committee on Human Services on Environment. It's and on environment. And then there's the check back that Health and Welfare wanted on these two reports to, as part of that report under section 4, that there's going to be a check back on how other states are regulating complex durable goods and food. And then a second update shall be provided as testimony on or before January 15, 2029. Should I move on? Then you get to PFAS and firefighting agents and equipment. Last year in Act 131, because of concern that PFAS couldn't be removed from all firefighting equipment, there wasn't a ban on PFAS in personal protective equipment for firefighting. Instead, there was a requirement that the manufacturer notify the purchaser of the presence of the PFAS in the personal protective equipment. And then the purchaser could make the decision whether or not, the informed decision whether or not to buy. And there were record keeping requirements for that purpose. The first change, though, is in the definition of what's intentionally added for that program. And it's using the same definition of intentionally added that was proposed for consumer products. So what the Attorney General and A&R negotiated with regulated entities is that same definition. And then beginning in 2029, instead of there being a notice requirement, there would be a prohibition on PFAS and PPE. So a manufacturer or other person that sells firefighting equipment to any person, municipality, or state agency shall not sell, offer for sale, distribute for sale, or distribute for use in the state any PPE to which PFAS have been intentionally added. However, that will not apply to respirators or respirator protection equipment in 2029. There's concern that the respirators will not be PFAS free by 2029, or at least affordable respirators or respirator equipment won't be available by 2029. However, in 2032, in section 10, the prohibition on PFAS and firefighting PPE will apply to all PPE, and respirators will not be so. The firefighters were in, both the professionals and the volunteers. The volunteers at first were concerned about the deadlines for this. There was also some misunderstanding about how this would prohibit the use of PFAS and PPE say they purchased, so they're, I'm blanking on the word, it's just, I'm just exhausted, I'm sorry. So their cycle for buying new equipment is a 10-year cycle. And so say they bought new equipment in 2038. That doesn't mean that they have to stop using it in 2039 when there's the ban on the sale of PFAS and firefighting PPE. They get to use that equipment for the next 10 years or however long they want to keep wearing PFAS and PFAS added equipment. But then at their next cycle, because there won't be the ability to sell PFAS and PPE, they would be buying PFAS-free PPE. So they would be buying PFAS PPE in 2038 when their next 10-year cycle for purchasing would be kicking in. So not a ban on use, not requiring every volunteer firefighter company to buy new equipment in 2029, 2032. Just that it's part of their cycle, whatever their cycle is. There was some concern that it might lead to kind of a rush to buy up the PPE with PFAS because of cheaper in 2038. That was kind of determined to be, well, that if that's the decision you want to make, if you want to put your employees in PFAS equipment for 10 years, well, that's your choice.
Representative Austin.
Do they need to notify the firefighters about that?
So there is a requirement in here. Why don't we look at it? That ANR do a report on the availability of PFAS-free personal protective equipment. And they're going to report back in December 15, 2028 regarding the availability of PPE that does not include PFAS. It shall include a summary of general availability, including whether respirators that do not include PFAS are generally available, and a summary of the cost of PPE. And then they have to give that report to the League of Cities and Towns to make available to municipal firefighting departments.
But does that mean that firefighters need to be informed about, I mean, they get the report, but is there any requirement that firefighters are made aware that there's PFAS in there?
They are already aware of PFAS. And I think it's an issue of concern for both the professional and the volunteer. There's just, I think honestly, the professionals would like to move to a ban ASAP. Whereas the volunteers want more time to figure out how and what they're going to buy. And so that's the compromise that was reached. The professionals really wanted it to be banned now. They say that there are alternatives available. They say that other states and other jurisdictions have already banned it, that there are PFAS-free respirators. The volunteers were just a little more reserved. They wanted to take more time and figure out what's out there and the cost. And that's what the report is supposed to help inform.
Representative Chapin.
I'm struggling a little bit to make the connections with the text. You were talking about some dates in 2038.
So it's 2038 is not a date in this bill. But there's a 10-year cycle for when firefighting, so if they bought in 2028, they're not gonna be buying new again until 2038.
Just missed that. Now I understand.
I mean, there's nothing keeping the professionals or anyone else.
No,
Is this, so these products are already labeled? It's already,
pardon?
they're already labeled PFAS free or?
They're marketed as PFAS free. I don't know if they're labeled as PFAS free.
Okay. And the difference is what between a label and a marketing? You're questioning whether they're really PFAS free?
No, if they're marketed as PFAS free and they're actually not, then that's misleading, that's consumer fraud. By labeled, I mean that there's something on their label, something on the product itself that says PFAS free. I don't know if that's the case, but I have definitely seen the marketing for it that says that the equipment is PFAS free. So there's one other component for the firefighting, and that is stationwear. Stationwear is what they wear their uniform shirts and pants in the performance of their duty, often underneath the PPE. Apparently, the stationwear has PFAS in it too. There was originally the concept of banning PFAS in stationwear, but stationwear is clothing. It's already subject to the prohibition. It's not a total prohibition. So under Act 131 and under this bill, textile articles are allowed to have a regulated amount of PFAS in them. Starts out as 100 parts per million and then ratchets down to 50 parts per million. So, and that goes into effect in 2027. Stationwear PFAS is already going to be largely phased out of stationwear in 2027. So there didn't need to be a corresponding ban on PFAS and stationwear, but there's going to be the notice requirement until the ban on PFAS and textiles. So if a firefighting company is buying stationwear, the manufacturer has to notify them of PFAS in that stationwear until 2027, when the ban on PFAS and textile articles goes into effect.
So if I understand correctly, I mean, you say there was already a ban on stationwear?
There's already a ban on PFAS in textile articles. There wasn't a total ban. It allows 100 parts per million to begin with, and then ratchets that down to 50 parts per million. So going into the future, there can be PFAS in textile articles at 50 parts per million. And so that's what stationwear will be subject to, because it is clothing, it's a textile article, apparel. And that's what happens in 2027. But before that, they get notice. 2026, before 2026.
So the PFAS in clothing, is that in there to make it water resistant? Did you, I mean, and I realize that's maybe beyond your whatever involvement with the bill, but do you know that?
I think last year there was testimony from manufacturers. It served multiple purposes, one of which is water resistance. And they convinced the legislature last year to allow for some PFAS in apparel.
Representative, somebody over here had their hand up. Bartholomew.
You mentioned the stationwear. Where was that in here? The language.
That is in section 11, which is on page 19.
Page 19. Section 11. Okay, thank you.
And then you get to the effective dates. There are some changes. So the definition of intentionally added takes effect July 1, 2027 for consumer products. The definition of cookware, you had changed to 2028. The Health and Welfare Committee was going to change it to 2027. They changed it back to 2028. And then for the PPE containing PFAS, that's January 1, 2026, and supersedes those provisions of Act 131. The prohibition on sale of PPE containing PFAS is July 1, 2029. Prohibition on sale of respirators containing PFAS is 2032. And it passed yesterday on voice vote on second reading. Only like 3 questions.
Representative Chapin.
Can you just explain the implications of the change to the deadline, change to the effective date for the definition of intentionally added?
Sure. So it's tied to the new products and not to the products that were banned last year, because those products had already been in a process of phasing out what under the old definition of intentionally added. But in 2027, it's going to apply to all of them. So you're giving those products that had already been regulated the regulatory expectation that they were working under. But in 2027, it's going to apply it to the new ones and all of the existing ones.
All right. Further questions? Seeing any? Thank you, Michael. Representative Bartholomew.
You said second reading was yesterday, so we don't have this bill back yet.
No, third readings today. If they go on the floor at 10, I hope I don't get called down there. But
I think they're distracted by other things.
yeah, they have another thing on their calendar that's gonna take some time.
That is.
Hmm.
That is.
You know.
Right, we will reconvene again at 11 o'clock.